it is our 2026 summer car forms update. They're a little ahead of schedule. Usually the new changes don't go into effect until around the 25th or 26th of the month, but this year, because I was on top of it, and I thought, oh, I'll get them all, you guys up to date on all the changes before they go into effect. They decided to make them go into effect on the 16th. So that was 2 days ago. The new forms should be in your car form library. So they should already be in there. If you have existing transactions, so transactions that were already created inside of Zip Forms, they didn't used to update those forms that were already in your file. You would have had to remove them from the file and re-add them. I think the last forms update, they figured out a way to automatically update those forms. I make no guarantees, so you may want to double check. And remember that you'll know if it's changed because in the top of the form, underneath the title of the form, it keeps fuzzing out. All right. Anyways, it shows like on this one, it says revised 6/26. That would be June of 2026. Now on the car forms library ones, your revised date is not going to be in red. It's going to be black. So don't go looking for red dates. They won't be there. But just know you can always look for that. The good news is there weren't major changes that are really going to affect you in your day-to-day business for the most part. They just updated some stuff. From what I've seen so far, it's not major. So we're going to go through the forms that are pertinent to you guys. They updated like, I don't know. There's a whole bunch of forms that got updated. There's a few new forms that got added, so we'll go over those as well. And just talk about what those changes are. If you have any questions, let me know. But again, nothing super major got changed. This is your residential lease after sale form is where we're going to start with, mainly because my computer chose not to open them in alphabetical order. So we're going to start here. This is their seller in possession after the close of escrow. So we close escrow, seller's going to remain in possession. We use the SIP form, the seller in possession form. If they're going to be there 29 days or less, if they're going to be there 30 days or more, we use this RLAS form. They just updated a few things. Number one, they broke out the rent into line items. So now we have four. We have the amount, the due date, and the proration. What did they agree to pay? When's that going to be due? And then what's that prorated amount, just if they're not staying in for the full month. So super easy update there. Made it clearer instead of being clear as mud in that section. And then down here, your major change. I don't think it likes when I scroll really fast as part of the problem. So I'll kind of keep an eye on it to make sure that before I update it. They just changed some verbiage here in the smoking. No big deal. You wouldn't even notice if it wasn't read that it had happened. So we're just going to continue on. The next thing that they changed was down here, which I actually like. So section 29, and this is going to be updated not just on the RLAS, but like the residential lease month to month agreement or any of the residential leases is going to have this updated in it. Okay, so I'm just covering the residential lease after sale because we don't do a whole bunch of leases. So I'm not covering all of the lease agreements, just the ones that we might use in our regular business. Section 29C for insurance. It used to just say tenant shall obtain liability insurance in the amount not less than blank, right? So that we want the tenant to have that liability insurance so it doesn't fall on the landlord's policy. But now it added for injury or damage to or upon the premise during the term of this agreement or any extension thereof. So it's right where we want that liability to cover damage, injury, or damage to or on upon the premise during the term of the agreement. Liability policy shall name the housing provider and property manager, if applicable, as an additional interest, requiring insurer to notify such person if the policy is changed, canceled, or not renewed, and as additional insured if available from the insurer. Tenant shall provide the housing provider a copy of the insurance policy before commencement of this agreement and a rider prior to renewal. Housing provider and tenant are advised to seek counsel from qualified California attorney or insurance broker regarding the availability of insurance prior to entering into this agreement. So keep in mind that when we close escrow on a property and the seller stays in possession, The buyer's policy of homeowners is now in effect. And technically, even if the seller hasn't canceled their policy, it's no longer valid because they don't own the property. So if there was ever an insurance claim filed during that time period, the seller's insurer would probably decline their coverage because they have a homeowner's policy and they're no longer the homeowner of that property. So it'd be an invalid policy. So if the seller stayed in possession, buyer's policy goes into effect. Buyer needs to check with their insurance company because they probably need to have that policy have a rider for a tenant occupied property because they are also not occupying the property. So buyers need to check with their insurance company on how to handle that time period that the seller is going to remain in possession. Seller needs to cancel their homeowner's insurance policy and get a renter's policy. And the renter's policy should have, I would check this box here, just that the tenant shall obtain liability insurance and it should cover them and they'd be listed as a additional insured. What happens when somebody gets listed as additional insured is the insurance company sends notices to the landlord to let them know that yes, the policy's good, you've been named, policy was canceled. So it just keeps the landlord privy to that information as well as make sure that they're covered in case the something happened on the property. Some visitor came over to visit the tenant and got injured on the property or something to that effect. So that's the big change on this one. Not necessarily a huge change, but a good point to discuss and make sure that you guys are aware of when we're allowing the seller to remain in possession. Any questions about that section there?
Yeah,
Amy,
Amy, now as far as the liability,
Yeah.
you recommend to have it at 300,000?
I would check. I would have the number one, please don't make a recommendation to your buyers because then
Right.
if you said, hey, 300,000 and then they, whatever ended up,
No,
something
I'm
happened with
talking
that.
about I'm talking about the tenants sitting in
Yeah,
there.
well,
They
that's
should
what I'm
have
saying.
three.
Don't make a recommendation to your buyers on what the tenant should have because
Okay. Okay.
if something went haywire, we're not experts in insurance. We don't know the answer to that. I would tell our buyers to check with their insurance person of what they would
Hmm.
recommend the tenant's liability cover.
Okay. Well, I was in
Okay.
13 years in insurance, so I was just asking.
Yeah, but so now you're a real estate agent
Right.
acting in a real estate agent
Right.
capacity. So I would instruct our buyers to check with their
Oh, okay.
insurance agent on what they recommend for this.
Okay.
Absolutely.
Perfect.
I just, right, that's one of those like CYA things. Like we just want to not be
Gotcha.
on the for those answers.
You got it.
Yeah.
Thank you.
Yeah,
I have a
absolutely.
question. Does it matter how long they're going to be remaining in possession to get that extra insurance? Like if it's 15 days, should they still, or
Yeah,
5 days?
yeah, even 15 days on the SIP, I think it mentions that I don't think that the housing provider or landlord gets mentioned as a additional insured necessarily if it's in that time frame, but even if they're staying in possession 7 days, buyer's policy goes into effect at close of escrow. Seller's policy is now invalid. If somebody else is living in the property, and the house burns to the ground, buyer's policy may not cover it because they're not actually in possession. Seller's coverage may not cover it because they don't actually own the property. So even if you have the SIP in place, we still need to be having those conversations with our insurance agents, our buyers and our sellers to make sure that it's covered.
Okay, thanks.
Yep, absolutely. All right. I think that was the last change on this one. Oh, no, second. Down here, section 43, there's a pool, hot tub, and spa addendum. That's now included as an option. So if there is a pool, hot tub, or a spa on the property, you're going to ask me what the difference is between a hot tub and a spa. I don't know. My guess would be a hot tub is above ground and a spa is like a permanent, but that's just a guess. I have no idea what the difference is, but there is a pool, hot tub, and spa addendum that needs to be included if the property has a pool, hot tub, or spa. I think that was the last change. I forgot about that. All right, there we go. Any other questions about the residential lease after sale? All right, moving right along. Then we have our residential listing agreement. There were some changes made to this one. They mainly are just clarification changes. So they were trying to make our jobs a little bit easier. Residential listing agreement. All right. So here in section 2, which is just the grid, C2, additional
I'm sorry,
compensation.
Amy.
Yep.
I'm sorry, what form is this? It went too fast for me to see it.
No problem. This is the residential listing agreement, the RLA.
Okay, thank you.
Yep. C2, additional compensation from seller's broker for additional effort needed to facilitate transaction if buyer is not represented by a real estate agent. This was an option that was on our listing agreement previously. Sorry, I've got something in my eye. Probably my finger. But this was on there before. It just wasn't very clear. So now they've broken down, hey, why would we want more compensation if the buyer's not represented? So they're just adding more clarification, trying to help our job be a little bit easier. This actually works in our favor. So if broker is not representing broker is advised to provide the unrepresented buyer with a buyer non-agency agreement. And if broker represents both buyer and seller, broker must obtain a separate written agreement with buyer that establishes broker's right to compensation on buyer side of the transaction. So they're just clarifying that, hey, the first part here in the first section of the grid where it says, hey, additional compensation. It used to say like additional compensation to unrepresented buyers or to seller's broker for unrepresented buyers. And now it's clarifying for additional effort needed to facilitate the transaction if buyer is not represented. So they just made it seem like, oh, that makes sense because we're going to have more effort. And then they're just clarifying that if the buyer's not represented, there should be a form that you have the buyer sign for that, stating that they're not represented, buyer non-agency agreement, stating that you're not representing them as the agency, so there's no implied agency created. And then obviously if you're doing dual agency, that is a separate deal. So that's that clarification there on C2. There's another thing down here. Let's see here. Our investigation reports, they added a new paragraph because they've renumbered the paragraph. So 7A, investigation reports, whether ordered by seller or broker pursuant to paragraph 7A, seller shall pay for any reports selected within 5 days of the beginning of this agreement. So that would be any of those listing inspection reports, right? Your past, your property inspection, whatever it might be. And then they've broken out paragraph 7A, which we'll see here in a minute. 4C, optional additional compensation for unrepresented buyer. Okay, that references that first item on the grid that was changed. If no other brokerage company is involved in the sale of seller's property because buyer is not represented by a real estate agent, seller agrees to pay broker at the additional amount specified in 2C2. If checked for services rendered, broker is advised to confirm that they are not representing the buyer by providing the unrepresented buyer with a buyer non-agency agreement. So just clarifying for that section that they added. And then down here, 7A, brokers and sellers. Hold on. What was this one? Oh, okay. Feel like that's not right, but that's all right. We'll just continue on. 7A, they added social media in here. So broker agrees to exercise reasonable effort and due diligence to achieve the purpose of the agreement unless seller gives broker written instructions to the contrary. Broker is advised but not required to order reports and disclosures, including those specified in paragraph 7E as necessary, advertise. It mentions those properties in there. Advertise and market the property by any method in any medium selected by the broker, including MLS, the internet, and social media, and to the extent permitted by these medias. So they just added social media in there so that it wasn't just internet. It includes social media, not saying that you have to use social media, but giving you permission to do so. Let's see here. I think that was it for our listing. See, just minor. They added social media. Oh, on the ownership and use of images paragraph where it talks about like it's going to get disseminated out there. It says seller also acknowledges that once images are placed on the internet or on social media, that we don't have control over who views them. Third-party use and taking of images, same thing here. They added on social media next to internet. So anytime internet was mentioned, they included social media. So just really, truly minor adjustments there on that residential listing agreement. Any questions regarding those changes or anything else on the RLA? All right. Sadie, you're welcome for bringing up that insurance issue with that RLAS. And on this RLA, just so you know, the listing agreement, whether it's a residential listing agreement, the vacant land listing agreement, all the listing agreements were updated with that social media and the unrepresented buyer clause. I'm not going to cover all of them because it's the same change on all of them. So I just covered the one that we use the most. All right, here is our new forms. We have two new forms. They eliminated the PRBS, which is the possible representation of more than one buyer or seller. They changed the form. So now there's one that pertains to, oops, sorry, more. Now there's one for the seller and there's one for the buyer. So attached to your listing agreement, you'll now see the possible representation of more than one seller, disclosure and consent for seller, and attached to our purchase agreements or our buyer representation agreements, our BRBC, you'll have the possible representation of more than one buyer, disclosure and consent. Okay, so here it just says multiple sellers, dual agency in a transaction, buyers and multiple sellers if seller is represented by a brokerage, right? Seller acknowledges that brokerage may represent prospective buyers of seller's property and consents to brokerage acting in a dual agency for both seller and buyer in that transaction. Seller further acknowledges that brokerage may represent other sellers competing for the same buyer and consents to brokerage representing both sellers and other sellers, right? That we're not just limited to one listing. Dual agency, they just updated a few random stuff there and just signing below. So they've separated out the buyer portion and the seller portion. I think that's fabulous. This one's now specific to sellers. There's a second one specific to buyers. So you'll see this now attached. Like I said, this one will be attached to the listing agreement. Any questions on the possible representation of more than one seller?
I have a question on dual agency. Is that on those forms as well, or is that in a different section?
It does talk about dual agency on this form. It also talks about it in your listing agreement, your purchase agreement. What's your question?
If a seller doesn't want dual agency, is there something that we check on the RLA that's different with these updates?
There is not something different with the updates for if they don't want dual agency. And remember too that dual agency is within the brokerage. Okay, so if Michelle has a seller and has the listing and I have the buyer, because we're under Realty One Group Fox, if I bring the buyer to Michelle, we are under dual agency because technically the contract is with the brokerage. So you may just want to confirm. I believe I already closed the window on the RLA, the listing agreement, but on the listing agreement, I believe that there is a section for both because I know there is on the BRBC that we covered a couple weeks ago. There's a portion that talks about dual agency within the brokerage and dual agency with the same agent representing both parties in the transaction. So, but nothing has changed regarding that in any of the forms. Did that answer your question?
Yes, thank you.
Yep, you're welcome. All right. So that's your PRBSS. I feel like it should just been called a PRS because it's the possible representation of multiple sellers, or the PRMS and then a PRMB. But, you know, what do I know? It's a PRBS-S for seller. And then there's a PRBS-B for buyer, which is right here. It's always a good day when it magically appears next. Okay, same thing here. This one is just going to be more specific for the buyers. They took out some of that seller information and focused more on buyers on this one. Okay, and then this one, they added sellers and multiple buyers, but it's the same thing, just saying that, hey, buyer is represented by the brokerage. Buyer acknowledges that brokerage may represent sellers of the property. Buyers interested in acquiring and consents to brokerage acting as a dual agent for both buyer and seller with regard to that property, and that we're working with other buyers and giving you permission to work with other buyers. So that's really the only change there. Again, these are new forms, but it's one form that used to exist. They just broke it into two, so it's not technically a new form. You're going to see this. It should be attached to your BRBC, your the shortened BRBC. I can't think of what it's called right now. And the my guess is it's probably attached to the purchase agreement, but it may not be attached to the purchase agreement anyways. It's not the RSPA. It's the, I don't remember. Starts with a P. Anyways, the temporary brokerage agreement. All right. And the next form that got some updates was our notice of broker involved properties. So remember, we want to supply this form to our buyers at the expiration or cancellation of our BRBC. Okay. And it just says, they just updated this with tenant. So now it applies for both buyer or tenant. Again, we don't do very many tenant transactions, so it really doesn't apply. But now this works for either the buyer representation agreement or a tenant representation agreement. We would have this notice of broker involved properties. For buyer representation only is B here. So just kind of be aware of that, but nothing big here. They just added, most of it's just a buyer / tenant now section there, and then a section that just clarifies that it's for buyer representation only, not tenant representation. So very minor changes to our notice of broker involved properties. Any questions before we move on?
I have a question. So
Yeah.
I had a BRBC with someone and I had been working with them since January. We extended it a couple times, but they just decided they're going to wait until August because the husband's gone. Anyways, it expired, but when I go to send them this form, there's no need to do all of the properties, right? Only the stuff within like the last month that could carry over that I would have. Like everything else is probably gone. And we went through a lot of properties.
So
Makes sense.
yes, number one, thank you, Ed. The PSRA is the temporary buyer representation agreement. I knew it started with a P. Anyways, and now to cycle back to your question, notice of broker involved properties on an expiration of a BRBC needs to be provided at time of expiration. So just a heads up on that. So if it's
Okay.
already expired, you've missed the window. So it really doesn't matter at this point. We just are hoping that they choose to use you if they do decide to buy a property. Secondly, the notice of broker involved properties and the BRBC, it covers any properties that you've seen during the time that you represented them under that agreement. So you can decide which properties you want to include on this notice of broker involved properties. Personally, if it was me, I would just keep an ongoing list for all of my buyers of the properties that I did work on their behalf. I called the listing agent for them. I inquired about potential properties. I showed them potential properties. I would just have an ongoing list and I wouldn't worry about going back and verifying which properties are still on the market versus which are not still on the market. Maybe one actually went into contract and now it's coming back on the market. Who knows? So I would just include the whole list because that's, I think if you're doing this right, well, we won't say right, there's lots of right ways to do things, but if you're doing this well, as you enter into an agreement with a buyer and we start working on behalf of that buyer in an agency capacity, I would recommend just getting in the habit of creating a list for every buyer that I'm working with. And anytime I do work for them on any properties, outside of just emailing the list of available listings, right? We actually have to do work on it. I would keep an ongoing list of those properties, whether they actually view the property or not. If they say, hey, what about this one? Can you look into this one? Do they have any inspection reports? Now I'm calling the listing agent. That's broker involved property. It goes on the list. And then at the time that it expires or we decide to cancel, I have an ongoing list. I just have to say, hey, it's on under section 4. We're going to check this box here for the attached list of broker involved properties. I'm already going to have that list done with the dates on it. I would just get in the habit of doing that if I were you. Trying to go back, like you're saying, like we've been in,
I have them all listed. I do have them
Okay,
listed.
yeah.
But here's I guess my other question is we had sent I believe Sunday was the day that the BRBC expired, and so a few days prior I had sent them the extension, and she didn't get back to me until the day that it expired to let me know that she was not going to be that they're taking a break on it. So would I have had to send this form on Sunday?
Yes.
Okay.
Yes.
Noted.
I mean, you could
Okay.
still send them the list of, hey, just so you know, here, it's expired. Here's the list of broker involved properties. I'm required to provide this to you based on our contract. That way they, if they read it, they would know that it wasn't provided on the right date. But if they don't read it, then they're going to feel like, hey, if we decide to purchase any of these, we're required to go back to Crystal.
Okay. All right.
How's
Thank
that?
you.
Yep. If it's a cancellation, so everybody knows, if it's the expiration of a BRBC, this list has to get provided on the date of the expiration. Or it says right here, right? Like prior to the expiration of the agreement, or if it's a cancellation, it's within 5 days of the effective date of the cancellation. So just so you know your time frames there, it's super important, because if we expired on Sunday, we provide them the list today. Hopefully they feel like that's good. But if it was ever taken and challenged, or they entered into contract on a property and you were going to try to challenge to get that commission, it would actually not hold up. So just a heads up on that. All right. So there we go. Minor changes there. Any other questions on this one before we move on? The forms changes are good because they bring up other questions that you might have regarding these forms. We do cover forms. The summer series is every Thursday morning. We're covering forms. We are diving into the residential purchase agreement next week. All right. So here is our liquidated damage and arbitration agreement. This is a separate form. So if we have our residential purchase agreement, towards the end of the residential purchase agreement, it talks about the liquidated damage or arbitration, and everybody has to initial that they agree, or nobody initials that they want the liquidated damage and arbitration. There's 2 separate clauses. We can agree to one without the other, but everybody has to be in agreement. Okay, they're updating the counter offers to include this, so that if everybody is not or is in agreement, that we can get everybody on the same page using this liquidated damage and arbitration agreement. This is intended to use with an additional signature addendum. So the ASA, we talked about that one last week, or the counter offer or amendment. So if we're changing the contract, we're countering, or we're adding an additional signature addendum, we want to pull this liquidated damage and arbitration agreement into it to make sure that everybody's on the same page. Liquidated damage and arbitration clauses require initials of all parties to be binding. Parties who have not initialed the applicable clauses in the agreement but want to be bound by either clause should initial in the paragraphs below. If at least one but not all parties either initial clause, example, there are additional signers, or it was omitted on the original offer, parties are advised to address those clauses by further written agreement, such as an LDAA. To clarify, any initialed paragraph is included or excluded. If the parties continue with the transaction and either of those paragraphs is not initialed by all parties, either in the agreement or this form or counterpart, that paragraph is excluded from the final agreement. So they've added some clarification here. Here's the liquidated damage clause. It gives the principal a place to initial here and print their name. And arbitration of disputes, you're going to see the same thing. Principals who do not agree to the liquidated damage or arbitration should not initial above. So this would be like, buyer submitted an offer, they agreed to the liquidated damage clause, seller signs the offer, but counters that they don't agree to the liquidated damage clause, and then buyer says, no, we want that included. So now the buyer sent a buyer counter offer saying, hey, yeah, we agree to the seller counter offer, except that we want to be bound by liquidated damage clause. We would include this with that buyer counter offer so that the seller could then initial that they've read and agree to it. So this would just be, we want all parties to be in agreement. So in the case that like buyer signs the RPA and says they want the liquidated damage clause, and then seller counters saying, hey, no, we don't agree to that. If they counter, they don't agree to it, we don't have to include this form as long as everybody's in agreement that we aren't going to use the liquidated damage or the arbitration of disputes. And remember, these are two separate clauses. We can agree to one without agreeing to the other. If the buyer didn't sign one of these on the purchase agreement and seller says, no, we want that included with their counter offer, you would include this form. So does that make sense to everybody? Yes? Anybody? All right. Sometimes this gets missed as the counter
Question on
offer.
that.
Say that again.
I have a question on that. So
Yeah.
I had the buyer. The sellers didn't want to agree to the liquidated damages. So does that mean that they would need to go to court if needed instead of arbitration?
So liquidated damage and arbitration are two separate clauses. So the arbitration is what helps, instead of filing a lawsuit against somebody, you should go to arbitration first. That is the arbitration versus the liquidated damage. The liquidated damage just presets the dollar amount for which a seller can go after a buyer for in the case of a breach of contract, 2-3%, or the deposit, whichever is less. So two separate ones. So yeah, if the buyer wanted the arbitration disputes and seller said, no, we don't want that, then yeah, technically if there was a problem that occurred during the transaction, you would go to mediation, and then the sellers could file a lawsuit, or buyers, either party could. It doesn't matter which one. You're not bound to arbitration.
Thank you.
Okay. Keep in mind too that on the residential purchase agreement, the arbitration only applies for those things that don't fall under things that would go into small claims court. So the small things don't have to fall under arbitration of disputes. If you haven't read that section of the residential purchase agreement, I would recommend that you do read the portion regarding the arbitration, or even on here, it talks about what is included and stuff. So, and what's excluded. All right. So and then the other thing is too, sometimes it gets missed, like buyer initials, the listing agent sends the seller the listing agreement for signatures and they miss the initial boxes. So now we've got a contract that's ratified, everybody's agreed to, signed, they're accepting it or whatnot, but seller forgot to initial. Then we would do an addendum at our amendment, an AEA form saying, hey, seller agrees to the liquidated damage clause, see form LDAA. Okay, and then you would include this and they would initial that, yes, we do agree to those things. Okay. There we go. All right, closing that one out. We have our exempt seller disclosure. So this one was updated. The TDS and SPQ also updated, but the exempt seller disclosure is sometimes the seller's not required to do the TDS. Okay, the transfer disclosure statement. They're still required to disclose any information they have regarding the property, but sometimes they don't have actual knowledge of the property, so they're exempt from that TDS. Even if seller is exempt from completing the TDS, seller may not be exempt from the water heater and smoke detector compliance requirements. See CAR Form WHS for more information. So they just added that, saying that, hey, just because you're an exempt seller for the purpose of the ESD, that doesn't mean that you don't have to include the other form. That was really the major change here. And then keep in mind that you need this for all units. So there's a line item here for the exempt seller disclosure is for all units, which is the default or only specific unit. So if you've got like a duplex or a triplex or a fourplex, okay, which is what would fall under the TDS and the SPQ, those disclosure requirements. Once we hit into 5, that's now commercial property. You could specify units here as well. That was the major change there on the exempt seller disclosure. Any questions regarding this form? Again, most of these are just minor changes this time. I appreciate that because they've been doing a lot of major changes, but this one's mostly minor. Here's our demand to close escrow. So remember, we have a notice to perform that is for all other contractual actions except for close of escrow. And we use our demand to close escrow. It's a 3-day default in the residential purchase agreement. Where if we want another party, whether it's the buyer or the seller, to get on the bandwagon and get escrow closed, we use this demand to close escrow. The update here is notice to the buyer, if you do not close escrow by the end of the time period specified in the demand to close escrow and seller has fully performed, seller, depending on circumstances, may cancel the agreement and bring legal action against you for damages, including but not limited to the deposit, cancel the agreement and authorize the return of your deposit, or bring legal action against you and force you to buy the property, specific performance. So it just clarified here, it added depending on the circumstances, because it's not a one situation fits all. And that there's always an option that they may have to cancel the agreement and authorize the return of the deposit, right? If we still have outstanding things going on there. So, and then buyer demands that seller close escrow. Buyer may, depending on circumstances, do any or some combination of the following: cancel the agreement, bring legal action against you because of your breach of contract, or bring legal action against you to force you to sell the property. So those are the options. It's got the seller portion of the demand to close escrow and the buyer portion. Any questions about our demand to close escrow form? All right. Moving right along. Here's our buyer representation and broker compensation agreement. Just trying to get my window to expand. Hold on. I'm frozen. It's coming. Maybe. Hold on. Are you guys still there? Oh, look, I can move it now. Maybe not. If you're there, give me a thumbs up or respond to me so that I know you can hear me. All right.
We're all good.
Oh, good. Oh, good. I was about to close out of Zoom and reopen because my preview has frozen. Okay, let's see if I can get it back working again. Otherwise, it's going to take me just a minute. All right, let me close out of preview and reopen everything. Give me just a second. Too bad preview isn't like Google Chrome, where when I go to reopen it again, it'll just automatically reopen everything that was open. But that's all right. All right, give me just a second. Some elevator music. Yeah, we definitely need some hold music. Does somebody want to provide us with some humming that would satisfy for the hold music or elevator music? All right, let's try this again. This is the problem with technology. It works until it doesn't. All right. Michelle, you can hum it for all of us. All right. Let's see if we get it to participate. All right, it's opening. It's opening. It's verified. It'll take it just a second. Then we'll be right back on schedule. While this is working, anybody have questions that you want me to answer for you?
I have a quick question. Maybe we can view it at the end. I don't know if I missed it last week. But I just did a purchase agreement, like a mock contract. And on the
Uh-huh.
very top portion, I don't have one in front of me, but on the very top portion, it has you click if you're having a dual agency. So in this particular instance, it was the same broker, but it was one agent representing the buyer, one agent representing the seller. And the boxes, when you click them, automatically, if you did the same broker, then it was saying the same agent was representing both. It would not allow you to click one broker and separate agents. Um, Maybe you can play with it and try and see what I'm talking about because I feel like that doesn't really make sense. But there was no way for me to say that one seller was representing just the buyer, but we had the same broker. If you have a suggestion on that.
I have no suggestion on that because it's a glitch with the car forms. It used to be, we got really excited because it used to just say, the option was either single agency or dual agency. And then they added dual agency, same agent, or dual agency, separate agents. But when you check one, like you said, for the brokerage, it automatically checks the other one and doesn't allow you to change it. So we got really excited when they released that update because we're like, yes, finally. And then they didn't allow you the option to be able to change that box. So I don't have anything for you on that, except that you could not check the boxes there in that section. You could leave them. Well, I don't even think you can leave them unchecked.
You can leave them
Um,
unchecked. Well, at least to print it, you could. So maybe
okay.
not send it.
So yeah, I bet you can. So if you can leave them unchecked, then when you go into the signing portion of it to set it up either in DocuSign or AuthentiSign, I recommend AuthentiSign. It's free, just so everybody knows. But when you put it into there, you can then add a checkbox. So you just have to remember to add that checkbox in for the appropriate checkboxes there.
Okay. That's a good idea.
That would be
Thank you.
That would be the best workaround. Yep. All right, it's still opening. My computer got really mad at me. All right. Oh, here we go. Okay, so we're gonna wait for it to magically appear back on the screen. I may go ahead and stop share and then reshare because I think that's going to be the best route since everything's so angry. Let's see. Sadie, I add the AC in. Is that correct? What's the AC? All right, I'll keep an eye open for that response. Agency, if that's the agency confirmation, you don't need to add the agency confirmation in at the beginning with the residential purchase agreement. Yeah. And we'll be talking about the agency confirmation because that one, they made some changes to but it really just is for if the check boxes are wrong, you can add the agency confirmation in. Yes. So if the check boxes were wrong there, or like sometimes the buyer's agent who submits an offer on your property puts the wrong agent information in that, then yes, use the agency confirmation. So if the check boxes are wrong, you can use that agency confirmation to confirm that, or which we'll get to here in a minute because I think it opened these maybe in alphabetical order. Or you can, like I said, if you're filling out the offer, you can leave those blank and then fill them in during the signing process so that it fills them in appropriately. All right, we're gonna come back to the BRBC, which is where we had ended, and we're gonna start with our additional agent acknowledgement. No problem, Sadie. Here, minor changes. So again, this is that additional agent acknowledgement. We talked about this one last week, stating that when you have more than one agent working with a buyer or seller, you would use this form so that no matter who signs, maybe only one signs on the RPA, but anybody who signs would count towards that. It allows you to reference a team here. And then it says check one box only if both paragraphs 1A and B apply, use separate AAA forms for each. So it's either A or B. Either multiple licensees are working with the seller or housing provider, or multiple associate licensees are working with the buyer. Okay. And we use one form for the buyer transaction and one form for the seller. Okay. And again, you might have two of these in your transaction. So if we have a BRBC and there's multiple agents and we use one of these forms with the BRBC, then we'll have one between us, the agent, and the buyer. And then we would also have one when we go to write the offer stating that, hey, there's multiple agents working with the buyer. And this is with regards to the purchase agreement. And then this one, the second one, the buyer and the seller would sign. So just so you know. So it just clarified there. Super easy change to that form. Any questions on the AAA form before we move on? Alrighty. This is the AOAA form, which is the assignment of agreement form. So we use this form anytime we want to, I can't get to the top of it. Anytime we want to add a buyer to an agreement or remove a buyer. So we can use this form. Maybe we have a purchase agreement and we're assigning the entire purchase agreement to a new buyer, right? So we can use this to take the existing buyers off and put the new buyers on. Maybe our lender said, buyer, we thought we could get you approved, but we can't. You need somebody else on this, a co-signer of some sort. So now we need to add that purchase person to the purchase agreement. We can use this form to add that person. Or maybe you've got, like, I see this often in like VA purchases where you've got husband and wife on there, and then lender go and you write the purchase agreement and the lender goes, no, we need to take the spouse off who's not the military member because whatever reason. We could use this form to remove them from the contract. So add a person, take away a person on the purchase contract, or assign it to a whole new buyer entity. Okay. Here we have partial or total assignment. It just said assignee is either buyer's own trust or a wholly owned entity of the buyer. So it just added the line item either. We started referencing paragraph 1E, which is the assignee is either buyer's own trust or a wholly owned entity of the buyer. So they just referenced that paragraph in here on multiple occasions. And then they added paragraph 4, assignee representation. Buyer's broker will represent assignee in the purchase of the property. Assignee assumes and agrees to perform and observe all the obligations and covenants of buyer pursuant to the buyer representation agreement, CAR Form BRBC or PSRA or other agreement, including the obligation to pay broker compensation. Buyer acknowledges and agrees that notwithstanding assignee's assumption of the buyer representation agreement, buyer is not released from any obligations or covenants under that agreement. Is A. So, right, hey, we're transferring, not only are we transferring to a new buyer, but the BRBC is transferring right along with them. I'm still due a commission. That's so that we don't get out of paying commission by transferring the contract to somebody new. Or B is buyer's broker will not represent assignee in the purchase of the property and shall have no agency duties to assignee. So they've added this verbiage in here to make sure that you know how you want to be represented. So that's 4. A and B. So the default is A, that, hey, everything transfers with this assignment of agreement. We are now representing this new buyer as well. If we check the box for B, that we're not representing the new buyer in the purchase, then we have options 1, 2, and 3 down here on the next page, which is assignee is not at this time represented by a real estate broker. Okay, that's the default. So default, if we're not representing them, is that they don't have a broker agency relationship. 2 is assignee will be represented by other broker. We fill in that line item there and check that box. Any questions that assignee may have regarding the scope of that representation or purchase should be directed to seller's broker if paragraph 4B1 applies and the assignee is unrepresented, or if other broker if paragraph 4B2 is checked. Otherwise, let's see here. Otherwise, unless agreed, seller's obligation, if any, to pay compensation to buyer's broker shall not be altered by this assignment. Other broker, if any, shall be compensated under the terms of the agreement with the assignee. Other broker, if any, shall provide a disclosure regarding real estate agency relationships, CAR Form AD, to assignee and confirm the agency relationship with assignee using the confirmation of agency relationships, CAR Form AC, in which any reference to buyer should be deemed to be the assignee. Okay, so they're just giving you more options on this form. Additional terms for seller's benefit. Assignee represents that assignee ratifies as approves and as assignee's own acts, all buyers' prior approval and acts pursuant to the agreement up to and including the date of this agreement. Assignee assumes and agrees to perform and observe all buyers' obligations and covenants in the agreement to be performed after the date of this assignment, right? Everything stays the same in the original agreement. Buyer acknowledges and agrees that notwithstanding seller's agreement to this assignment, buyer is not released from any obligations or covenants under this agreement. D is other terms, and E is parties acknowledge and agree that they have been advised to review this assignment with a qualified California real estate attorney and or accountant prior to signing this agreement. Brokers and agents make no representations as to the proprietary adequacy, legality, or tax consequences of this assignment. So that was a lot of information adding into when we're going to add somebody to the contract. Down here at the bottom, the seller has, without releasing buyer from obligations or covenants under the agreement and preserving all rights and remedies under the agreement, and in consideration of the covenants contained herein, seller consents to the assignment. So know that seller can decline the assignment, but they have to have a reasonable reason to want to do that. It talks about it in the purchase agreement if you want to look further into what grounds the seller has to deny it. And then also the assignment of agreement is in the residential purchase agreement. The default on that is 17 days. You have 17 days from the acceptance of the contract to add or take buyers off. I oftentimes, when I write the residential purchase agreement, I have that AOAA, the assignment of agreement, match the escrow period. So anytime I can add somebody or take somebody off as necessary. Questions on the AOAA form? All right. Moving right along, that one had some of the more major changes. Our next form is the buyer counteroffer form. So they've updated that. Here they've updated it, right, with the liquidated damage and arbitration of disputes to be binding. Okay. Initialed by all parties in the offer or addendum, such as the liquidated damage and arbitration. So they're bringing that addendum in here. Here is if it's going to be attached, we can check that box that we're attaching the liquidated damage and arbitration agreement to this counter offer. The next one, they just titled down payment, loan amount, deposits, and credits, right? The down payment loan amounts will be adjusted in the same proportion as the original offer. So if it was like 80% loan amount to 20% down payment, and we change the purchase price, we're adjusting those in the same proportion. They stay at those percentage. But the dollar amount of any initial or increased deposit and seller credits shall remain unchanged from the original offer. Okay, so unless otherwise agreed, down payment and loan amounts get adjusted. The dollar amount and any initial increase of the deposit and any increased deposit and seller credits shall remain unchanged from the original offer. Now, know if you wrote the offer with a percentage for the seller credits, that's going to stay the same percentage. But if you said, oh, well, it's a $500,000 purchase and we need 2% in seller credits, we need $10,000. So we wrote $10,000 in there. It's not going to adjust. If we move the purchase price to $510,000, the seller credit's not going to automatically adjust with that. Okay. Or if our deposit was factored on 1%, at 5,000 and we change it to 510,000, the deposit's not going to automatically adjust. It stays at 5,000. So if the seller wants to adjust that, or the buyer needs the credit to adjust, we need to recounter that as well. You're going to see these same changes too in the seller counter offer. The appraisal or contingency gap, unless otherwise agreed, if in the original offer the appraisal contingency amount is calculated using an appraisal gap, then the dollar amount of the gap shall be deducted from the final purchase price to determine the appraisal contingency amount. Meaning that if we wrote the offer at $500,000 and said, hey, we're willing to, as long as it appraises at $490,000, now we're agreeing to $510,000 in the counter offer. It's not now a $20,000 gap. It's still a $10,000 gap. So that's just saying it automatically adjusts based on the difference in the dollar amount. Addendum or attachments. Here we can attach things to this expiration. Any questions on that buyer counter offer? They also drew a box around this late acceptance. Just so you know, most times when you see a box around something, that means it's an optional signature. So if we're putting it through something like AuthentiSign or DocuSign, and it automatically, this is a buyer counter offer, so buyer signs there. Sometimes it automatically assigns these signature lines as well. We don't want to sign these, so you want to go in there and delete these. With our buyer counter offer, we're just signing this top line here. And then we're waiting for seller's response. Only if seller is delayed in getting the counter offer back to us and it's expired, would the buyer sign this bottom section saying that, yep, we're still moving forward. All right. Plugging right along here. Oh, we've made it back to our BRBC, our buyer representation and broker compensation agreement. Oh, this is just a minor change here. This just clarifies somewhere in here that if the contract is assigned, right here, section, I was looking for 4B5, unless otherwise agreed, buyer assigns the buyer's rights to purchase any property described in this agreement for which the buyer has entered into a contract to purchase, then the broker shall be entitled to the compensation specified. Such compensation shall be reduced by any amounts the assignee pays to broker. Okay, so my contract is still with this buyer. We're moving that over. That would mean that the new buyer is responsible for that compensation, but ultimately the responsibility of making sure that I get paid still falls in the original buyer's hands. I believe that's the only change. They made a few like little grammatical changes, nothing major. And again, that just falls in line with the AOAA form, the assignment of agreement form. All right, that was our only change there on our BRBC. Continuing right along, we have our, oh, we talked about this one, demand to close escrow. So let me get out of that one. Oh no. All right, hold on. All right, residential. Oh, we have this one already. Hold on. All right, we have a TOPA form. That's our tenant occupied property addendum form. So we use this TOPA form anytime we're making an offer on a property that's tenant occupied. Okay, we want to include that we're going to receive a copy of the TOPA forms. Okay, because the TOPA forms describes whether the property is going to be, we want to include this TOPA. Is the property going to be delivered vacant, or are the tenants remaining in possession? Okay. Because it gives you the option, like if we were doing a 4-unit property as an FHA purchase, which you can do, but the owner has to occupy 1 unit, then we may want to specify which unit is going to be vacant upon close of escrow so that the buyer can move in. Usually the lender will require that. So this just describes whether it's the property or unit/units. So which ones are going to be vacant. The assignment of tenancies. Upon close of escrow, seller assigns all rights under existing leases, rental agreements, and tenancies to buyer. This does not relieve the seller of any contractual obligations under the agreement, just saying that, hey, all of our rights are transferring to the new buyer. Government compliance. If attached, the RCJC TOPA form is for informational purposes. Unless the parties request it to be added to the lease agreement, is not required to be filled out by buyer and seller. Buyers advised to review the form and verify its terms are incorporated into any leases buyer is assuming. Law described in the RCJC/TOPA may apply even if the property is intended to be delivered vacant. If the occupant does not vacate at close of escrow, the application of the Tenant Protection Act, buyer and seller, may be different depending on how each holds title to the property. So it's just pulling that in to it so that it's included. And then other addendums or documents that can be included with this TOPA form would be rent cap and just cause addendum, the rental property owner advisory, or other. Then they renumbered everything there. Security deposits down here, section 7. Seller shall provide any photographs from the commencement of the lease are related to the current tenancy, right? So those photographs, that would be like the condition of the property. Seller is now required to make sure that the buyer receives those condition of the property so they know what the condition was when the tenant took occupancy. Any move-in reports, in an itemized of all lawful deductions made from tenant security deposits, if any, and a statement of the security deposit remaining after any lawful deductions have been made. There's a sample letter change of ownership and security deposit allocation. So this car sample letter, just so you know, if you go into your car forms library, when you go to add forms, there's a drop down at the top that most of you don't even realize exists. But if you click on that, it normally says like the car forms library. If you click on that drop down, there is a sample letter library. Go in there and check it out if you haven't done that already. It's pretty cool, but that's probably where you're going to find that car sample letter change of ownership and security deposit allocation form. So check it out. That's where that would be. Security deposits, if any, to the extent that they have not been applied to by seller in accordance with any rental agreement and current law, and all prepaid or unearned rents, if any, shall be transferred to buyer upon close of escrow. Seller shall notify each tenant regarding the security deposit in compliance with California Civil Code. So, right, it's just saying that, hey, any unearned rents, security deposits, it all transfers to the new buyer. All right, questions on our delightful TOPA addendum. I guess it's just a TOPA. It's not a TOPA addendum. It's just a TOPA, tenant occupied property addendum. Okay, remember, we want to use this for any tenant occupied property, even if the tenants are supposed to be out before the close of escrow. If the seller has told you, hey, yeah, tenants are supposed to be out, I would still include this form and say, hey, we want all the property to be delivered vacant, okay, before the close of escrow. Okay, just throwing that in there. All right. Moving right along, we have a new form. So our other new form, so we had that PRBC possible, that's now PRBC-S and PRBC-B for the buyers, right? Our other new form is our septic well and propane tank questionnaire. And the so one's an SWPIQ and one's an SWPI-C. Okay, so this it replaces, there used to be just a SWPI, a septic well, propane tank, and property boundaries addendum type form. They've broken it out, so now there's a questionnaire form and this, which allocates the cost. They also put it into a grid format to make it easier to go through. I think it was already in that grid, but they kind of broke it up a little nicer. So this is going to replace that other one. So you'll notice here, so for any properties, right, this applies. We don't use this for all properties. It does apply to like country properties. Here's our septic inspection and allocation of costs. You've got the inspection, location. If they have to excavate the septic to find those lids, how long do you have to access for that? Right? Pumping, who's going to pump it? And if there's a certificate or clearance to be prepared, who's going to do that? Okay, so we check what we want. And then we check who pays. Okay, and then there's additional terms like inspection and report to be prepared by a qualified septic professional, locating and identifying the septic tank, septic system or tank only, cost other than excavating to be able to gain access. Okay, so there you go. It just clarifies all of that. Here, if in order to obtain the certification clearance, additional costs are needed to repair the septic tank or system or to otherwise bring it into compliance with Apple law, further written agreement regarding costs and liability is required. So this is saying, hey, we're not discussing repairs with this. That's going to be discussed separately. Okay. There you go. Next section is the well inspection and allocation of costs. We've got water productivity testing, bacteria testing, chemical or radiological testing. Who's going to do it? Do you want it done? That would be, we check the box. And who's going to do it? Who's going to pay for it? And then you also can specify on this one additional terms provided by. Let's see. Then we have government report. That's usually provided by the seller. Okay, and then other. Again, here, if there's additional cost needed to repair the well or bring it into compliance for the written agreement. So we're going to discuss that separately. You have your propane tank, right? And we would use this form. You can use this form if there's a septic well, no propane tank. You can use it if there's a well, but no septic. It's on sewer, right? With no propane tank. So it can be any combination of these four things. You could use this form. If there's a propane tank on the property, who's going to measure the remaining propane? Any propane remaining in the tank shall convey as personal property to buyer at no cost, or buyer shall reimburse seller for the cost of remaining propane, and then other. Okay. If we are not worried about the cost or whatever, we could not worry about measuring if any propane remaining in the tank is just going to transfer to the buyer at no cost. Okay. Property monument, quarters, and boundaries. Check all that apply. You have locate and identify property monuments, locate and identify property corners, locate and identify property boundaries, other surveyor services or other. Okay, lots of options there. So this is the new SWPI-C. So this is pretty similar to our previous form with a few changes in there, but we're going to allocate those costs as well. So SWPI-C. Any questions about that form? Okay, if there is a property that has a septic, a well, or a propane tank, we would want to include this form as part of our seller question disclosures. It answers questions about the septic system. Okay. Size, capacity in gallons. Is there a gray line diversion system? Were any inspections or repairs done without permits, right? So all these questions. The well, okay, all these questions pertaining to the well. And again, the seller's only going to fill out the part that pertains to them. So if there's no well, they don't fill out the well section, but if there's a septic, they fill out the septic section. Okay. Are there any water tanks, right? How big? And then propane. If there's a propane tank, we want to include this questionnaire as well. So again, this is the SWPI-Q Q. And if there's a septic or a well or a propane tank, we want to include this because sometimes propane tanks are leased, sometimes they're owned. Is the lease transferable, right? So what is that? Is there a cost associated with that? What's the term of the lease? What's the amount? Is the tank owned? What's the approximate age of the propane tank? The capacity? Who's currently providing propane? All those questions get answered here with the SWPI-Q form, seller signs, and then buyer sign. And we want to do that as part of our seller disclosures. Any questions about the SWPI-Q or SWPI-C?
I noticed there's a lot of detail in there. What if the seller doesn't know the answer to some of those questions? They just leave it blank?
I would write on, instead of leaving it blank, if there's a propane tank and they don't know, I would write unknown
Okay,
instead
thanks.
of leaving it blank, just so we know they didn't skip it, because technically they would need to check each box for yes or no for the section that pertains to their property. So like, is there well metered? If they're like, I don't know, it's probably not, but you know, they could say unknown. So yeah. Most of this, the seller's probably gonna know most of this information if they have one of these systems, but they may not, so they can just put unknown. All right. Hold on. Moving on to our next form. Seller's purchase of replacement property. So again, we use this if the seller is purchasing, the sale is going to be contingent on them finding and entering into contract on a replacement property. It just specifies here in 1B, which is seller has entered into contract to acquire replacement property. Seller shall deliver to buyer within the time specified in paragraph 3 in 1 of the agreement or it's attached proof of replacement property, either a copy of the contract for purchase of replacement property and the contact information and escrow number for that purchase, a signed lease or rental agreement for replacement property, or other written evidence of replacement property. So it's just saying, hey, if we're already in contract on a property, we still have to provide proof of that, which in the time specified in 3 in 1, which is going to be down here. 3 in 1 of the agreement. That's going to be of the purchase agreement, the RPA. So that's the major change there, just clarifying that if they're already in contract, that still needs to be provided. Any questions on that SPRP? All right, our next one is our SPQ. They made a change to the TDS as well. Just so you know, the major change here was that I believe they just provided a line item for the units so that you can say this is either for all units or which units. And then they updated some of the numbering. They broke it out to make it a little more clear. Okay, documents include any reports, inspections, disclosures, warranties, maintenance, recommendations, estimates, studies, surveys, or other documentations that pertain to the condition or repair, any improvement. So they just broke this out. It was just a paragraph format. Are you the seller? And then they asked, I think before, like, do you have any previous inspections or something to that effect, or documents? So now they've broken that out a little better. Like, are you the seller aware of any documents regarding the property that were prepared before your ownership, whether you were in possession or in the possession of others, in your possession or the possession of others, right? Are you the seller aware of any documents regarding the property? And documents are defined up here in section 5, 1, 2, and 3, those Roman numerals, or provided during your ownership. So it's just asking them to answer yes or no, and then provide the explanation of what those documents were and include them. Oh, and then there's a line item here. If this property is a duplex, triplex, fourplex, this SBQ is for unit number blank under the property address. It should auto-populate that once you fill it out on the top line. Okay. Nothing major there. If yes to any, provide the explanation, just clarification there. Existence of a septic well propane tank, if yes, provide form SWPI-Q. So this is pulled in now to that seller property questionnaire. Okay. Let's see here. They just added some clarifying statements. And then that unit number gets put on the top of each page next to the address. Is the property tenant occupied? If yes, do you have photographs from the beginning of tenancy? And if in your possession, providing along with any other move-in reports created at the beginning of tenancy. So they pulled that in as well if it's tenant occupied. Keep in mind, tenant occupied is if anybody besides the seller is occupying the property. So it could not be somebody actually like paying rent. It could be the seller's daughter is occupying the property, even though they aren't seeing it in a tenancy format. That would be a tenant to the property. FYI, anybody but seller occupied. Any questions on that SPQ, those changes that were made there? All right, the next one is that seller counter offer, and the same changes on the counter offer you'll see on the buyer, or sorry, the seller multiple counter offer. And it's the same things we already talked about with the buyer counter offer. So this looks very similar, if not almost exactly the same to our buyer counter offer. It just is the seller counter offer. And again, you'll see these same changes on the seller multiple counter offer. So I'm not going to go over those. It just mentions that liquidated damage addendum and the gaps for appraisal contingency and those down payments, deposits, that type of thing. We have our statewide buyer and seller advisory, making sure that they know they should retain their own professionals, even if you've got an existing report. More explanation. Here's our table of contents. And then they gave you your page number and they added the paragraph number. So if you were looking for accessory dwelling units, it's not only on page 5, but you're going to find that in section B1. Okay, so they made that a little easier for you to navigate to where you're looking for. And then they redid the numbering. They changed just a little bit of grammatical things, but not like anything major on the rest of this. Oh, California experiences wildfires that may damage or destroy many properties. Brokers also recommend that buyers hire a qualified California real estate attorney to address any questions or concerns buyer have regarding title, preliminary title report, or matters addressed in this paragraph. Just so you know, I would highly recommend, if you don't have it yet, that you make sure you have a relationship with probably 2 or 3 California real estate attorneys that you can have on your list of service providers that you provide to your buyers. Might be a good idea, just so you can even give them some options with their home inspection options. They also have options for real estate attorneys. Land lease, they just clarified some stuff in the land lease that you're not going to own the land. We don't do land leases, so we're just going to move right along. Retrofitting, they added in sprinklers and other fire suppression systems there for point of sale requirements, you know, like in Woodland where we have to have the fire suppression system inspected. So just plugging right along. Minor changes to our statewide buyer and seller advisory. And just so you guys know, I usually provide this with the buyer representation agreement or the listing agreement. Even though it's signed between the buyer and the seller, I like to put this up front. We're just getting to the end. It's like 14. Oh, it's 15 pages now. So we're just scrolling, making sure nothing else that they didn't mention and I wasn't aware of. Yep, that's it. So just those changes, mostly grammatical. They changed the layout and format to make it easier to find things. Then we have our seller's advisory. This is attached to our listing agreement. Hold on. Oh, here. here we have, oh, because they updated it having to do with the disclosure requirement for the FERPTA disclosure. Or no, not the FERPTA, but the new disclosure that title has to double check with. I don't remember what it's called. Let's see here. Seller's advisory is the FINCEN reporting requirement. So they updated that for all cash or entity buyers and wholesale buyers. They just added a portion in there for the seller. Okay, because just saying that, hey, under federal law, if in force, a reporting person, typically escrow or title responsible for closing, is required to collect and report to the U.S. Department of Treasury certain information about buyer and seller when the property is a residential property with 1 to 4 units or vacant land intended to be improved with a residential dwelling of 1 to 4 units. The buyer is a legal entity or trust, and the buyer is making an all cash purchase or financing the purchase through a bank or other institution that does not have an independent money laundering reporting obligation. So it's just clarifying what has to be done here with regards to that. They also added under marketing considerations in your seller's advisory. We'll be covering the seller's advisory, just so you know, we'll be talking about it more in August, probably. We'll talk about seller forms. Most of July is going to be spent in buyer forms, and then August will be seller forms. Open house considerations. While holding an open house can be an effective way to attract buyers to a seller's home, doing so can present risks. No one can definitively know who will enter the home or for what purpose. The agent holding the open house will neither have the ability at all times to monitor the activity of every person coming to view your property, nor to assess whether such visitors are entering the home intending to consider it for purchase or for some other reason. Some visitors will respect your real property, personal property, and possessions, while others may not do so. Read paragraph 4D for further information. You should discuss with your agent the benefits and risks, including open houses, as part of your marketing strategy. So just know that that section is now in there. Any questions on that seller's advisory? Just updates for that FinCEN reporting. I don't know what they're really calling it. And then open houses. Next is changes to the request for repair. It just further clarifies when to sign the bottom portion. So we have the buyer's signature. We have the seller's response. And then it clarifies if only paragraph 1A is checked in this section, then the seller is accepting buyer's request and no further signatures are required. If either or both paragraphs 1B or C is checked, then a buyer must agree to paragraph 1 below and sign in that section in order to form an agreement. So they just added clarity there as to when to sign this bottom agreement. Any questions on that request for repair? Alrighty. The California residential purchase agreement are, just so you know, on the listing agreement, I think I mentioned that, but all those changes applied to all the listing agreements. Same here with our purchase agreement. This applies to all the purchase agreements, whether it's a vacant land purchase agreement, a new construction purchase agreement, whatever it might be, these changes applied to all of them. Potentially competing buyers and sellers. The parties are advised to discuss with their agent the broker's policy on dual agency and multiple representation of competing buyers and sellers. So this added that line item in there. Seller financing form SFA is attached for seller financing. They just mentioned the form for that. We have seller financings are really common in North Idaho. I don't think I'd really ever encountered it prior to this. It's not a huge thing in California, but you might come across it on like a property. Maybe we're asking the seller to finance the down payment, or maybe we're asking for like a land that's owned outright to be financed by the seller. There are some benefits to both the buyer and seller for that. Other seller credits or payments, this does not include buyer broker compensation. So this is not there. So we have seller credit to buyer for closing costs is G1, And then G2 would be seller credits or payments for other. And then you specify what it was for. We don't use this for the broker because that is G3. Okay. Appraisal here. Appraisal contingency based on appraised value at minimum purchase price is the default, or blank, we check the box and fill in a line item less than the final purchase price. The appraisal gap. Okay, so this is a change. So we used to say, well, the purchase price was 500,000, and as long as it appraises for 490,000, we're good to go. Okay. Now, if we're doing an appraisal gap, we're saying the gap. So in that instance, our purchase price was 500,000. We're good to pay 10,000 over the appraised value to make this happen. We would put 10,000 in there, not 490,000 anymore. This makes so much more sense. I'm glad they made this change. Makes more sense. So we're going to put in the gap that the buyers are willing to pay over appraised value if we think it's not going to appraise. Okay. The default though is purchase price. Oh, here, wait, pause. Back up here. Items included, all items specified in paragraph 9B are included and the following if checked and existing. Okay. So if we check something like dish or microwave now, and there's no existing microwave, then it doesn't matter. It doesn't count. We don't have to submit a counter offer on that. Okay. We may do an addendum down the road that just states the following items don't exist in the property RPA to P1, right? But we don't have to counter on it anymore. There's a box there for the optional wildfire disclosure report. There's a box here for the septic well and propane tank boundaries form, the SWPI-C, right? The allocation of costs for that. Keep in mind too, I'm just going to throw this out there that if it is a property with septic well, propane tank, and we check this box and we're having the septic inspected, not just pumped, or we mentioned that we're having the well inspected, the lender's going to want to see those reports. I'm just throwing that out there so that you're aware of that. They're also going to want it to be clear. Other disclosures there, buyer and seller advisories. They just updated some of the names of those. They changed some of the titles, warranties and access. Contingencies here. Plugging right along. They're saying that the pool fencing is included. So if it's removable pool fencing, that's now included with the sale. They clarified that. We all thought that, but you never know. I appreciate you guys hanging with me. I really thought we would go 2 weeks with this, but then, you know, they went and released these forms last week. So, or earlier this week. Here's your septic well propane tank advisory. So they've got a line item for that as well now. We already covered that disclosure. If you've got here property available, okay, let's see here. This delivery of investigation report shall not include any appraisal except an appraisal received in connection with FHA or VA loan, which buyer shall deliver to seller at earlier of removal of buyer's contingencies or cancellation of this agreement. So it's clarifying when a VA or FHA buyer is required to provide seller a copy of that appraisal. Okay, so appraisals on conventional loans not required to be handed over to the seller. FHA and VA are because they go with the property if we cancel. So here the buyer's agreeing to either turn that appraisal over at the removal of buyer's contingencies or cancellation of this agreement. That should be the loan contingent or the appraisal contingency. So just know that that's due at that time. I appreciate that they added clarification there. Seller's right to cancel must be done in writing and signed by seller. Buyer's right to cancel must be done in writing and signed by buyer. Down here, demand to close escrow. after the demand to close escrow period has lapsed, any subsequent cancellation must be delivered in writing and signed by the party canceling the agreement. If seller cancels based on demand to close escrow and buyer still has a contingency, seller shall authorize the return of the buyer's deposit except for fees incurred by the buyer and other expenses already paid by escrow holder pursuant to the agreement prior to seller's cancellation, provided buyers acting in good faith to satisfy the contingency. So they add some clarification there on what happens if there's outstanding contingencies. Notice it didn't specify which contingencies, just any contingencies. Then the deposit goes back to the buyer. Here's that federal residential real estate reporting, the reporting rule. This is for that at FinCEN reporting, contractual requirements, escrow compliance. So they added the section to the purchase agreement for that reporting requirements. I believe that's all. Getting to the bottom. Any questions on those changes to the residential purchase agreement? All right. I think we're just about done. We covered the listing agreement already. We covered the possible representation of buyer and seller. Notice of broker. I think we're at the end. Liquidated damage we covered. Exempt seller disclosure we covered. That get us to the end. Any questions about any of those forms? I appreciate those who were able to stick in till the end. It took us an hour and a half. I appreciate it. Any questions before we wrap up today? All right. And for those that haven't been on previously, I don't believe there were any changes to the MLSA, Carly. There is a form that references the MLSA now. Seller, they eliminated the seller's instruction to exclude form, the SELI, because it's duplicate information on the MLSA. But other than that, I don't believe they did any changes, at least that they mentioned or pointed out. How's that for an answer? You're welcome. For the past 2 weeks, we've been covering the BRBC and the attached forms to that BRBC. So you can go back and catch those in replay mode. For that, we are working to transfer over to the new platform to encourage you guys to show up on time and to be present for the trainings. The trainings won't be as widely available for rewatching unless you're in the mentee program, then they will be. And next week, we're going to start diving in with the residential purchase agreement and all the attached buyer forms to that residential purchase agreement. That'll probably take us through July. And then in August, we'll start with the residential listing agreement and the forms attached to that. So we covered the BRBC and the attached forms. Now we're headed into the residential purchase agreement. It's our summer series. We'll be here all summer, Thursdays, 9 a.m. We'll see you guys next week.